Good morning, everyone. Welcome to this webinar from Wozniak Legal. My name is Grzegorz Wozniak.
And my name is Filip Kowalczyk.
We are speaking to you from the very heart of Warsaw, from our office in Warsaw. We'll talk today about the new law on state labor inspectorate and consequences for businesses. Before we start, short introduction of ourselves. My name is Grzegorz Wozniak. As I said, I'm a Polish commercial lawyer. I specialize in M&A and corporate law. I'm joined today by Filip Kowalczyk, who is Polish attorney at law, is our lead specialist in employment law and high-stake litigation. Filip has extensive experience in Polish court, has won several landmark cases in unfair dismissal and breach of confidentiality. And Filip regularly works with clients in employment law. Is this correct?
Yes. I was also trained as a judge.
Yes, that's an important feature. So if you want to know how to speak to a Polish judge to win your case, whether you are victim or defendant, this is the man to talk to. Now, briefly about our webinar, we intend to go on for about 20-25 minutes and give you just basic information why really the audit of B2B contracts is necessary. You can ask questions during the webinar by clicking the question mark button. We'll try to answer this question at the end of the webinar. You can also ask us a question by email or calling us. Our details will be later presented at the documentation of webinar. Agenda for today is why auditing Polish B2B contracts is absolutely necessary. Why do you have to audit B2B contract if you run the business in Poland? Short background information. The reason for the obligation to audit contract is the new law which has been signed this year and will enter into force on 8th of July this year. And the new law on state labor inspection grants new extraordinary powers to this body. What is, for those of you who are foreigners, short explanation, state labor inspection is a governmental body whose task is to oversee compliance with employment law. State labor inspectorate traditionally were looking at compliance with various working regulations like health and safety, working conditions, working time, and very often work accidents. Now, in addition to these tasks, there will be also obligation to review civil law contracts, which could be reclassified as employment contracts. Maybe the easiest explanation for you what is going to happen from the 8th of July will be this. Under the current rules, if you were speaking from the perspective of a contractor, if you are on a B2B contract, but effectively your contract contains some employment-like elements, fixed hours, working from Monday to Friday, and subordination, then you had to go to court, you have to prove your rights in the courtroom and obtain a judgment from the civil court on conversion of your B2B contract into employment. This was extremely difficult, and labor inspection had nothing to do with this. Under the new rules, labor inspection will have the power to actually reclassify your contract or your B2B contract into employment agreement if they decide that your contract contains employment-like elements. So there is a huge change, and many businesses traditionally have been using in Poland B2B contracts and other civil law contracts. So that's why we suggest that every Polish company which uses civil law contract in their day-to-day business should do the audit of the B2B contract and take decision what to do. It is not that these contracts will be forbidden, but they have to be used wisely. And if any contract contains resembles more employment than that equal relationship between the parties, then it would be better to change these contracts into employment agreements before the law comes into force. We have prepared some slides for you So this is agenda for our today's meeting, a brief overview of the labor law changes which I actually did and what will change from the 8th of July, and information what actually turns, what could be a trigger changing or causing reclassification of B2B contract into employment. This is, as I said, it will the law is coming into change from the 8th of July. Yes, and if you could, Philip, clarify what maybe just a short introduction to the slide also, that as a matter of fact, nothing changes in material law because the rules stay as they are. Of course, we know that the law is always changing. Yes, it's adapting to the new situation in the society. So the law is always changing gradually. But this change, this new law on labor inspection does not change material letter of the law, but the approach to these issues. So please explain what is the employment agreement.
So, pursuant to the Polish Labor Code, by establishing an employment relationship, an employee undertakes to perform work of a specified type for the employer and under the employer's direction, as well as at a place and time designated by the employer, while the employer undertakes to employ the employee for remuneration. And employment under these conditions constitutes employment based on employment relationship, regardless of the name of the contract concluded by the parties. So accordingly, the term employment relationships refers to an activity possessing the following characteristics. So the first one is remunerated character. So the work is performed for remuneration. The second one is a personal performance. So the work must be carried out personally by the employee. The third one is continuity of performance. So work is understood as an ongoing activity, repeated on a daily basis or at regular intervals, rather than an one-off product or a single task. The third one is employer's risk. So the employer provides tools, material, and other resources which are necessary to perform the agreed duties by the employee. And moreover, employer bears the negative consequences of non-fault errors made by the employee, and as a rule, remains obliged to provide remuneration even in cases of operational disruptions such as downtime or adverse economic condition affecting the enterprise. So this is mainly the economical risk. And the last one is the subordination to the employer. So it means that the employee is required to follow work-related instructions issued by the supervisors and remain at the employer's disposal at the workplace or another designated location.
Yes, correct. So and what's important, I will just add to this, it is not so much important the labor of the contract, whether we call it, what would be the title to the contract. The labor inspection or the court will look into this contract, will try to compare, and as I mentioned already, they will look whether the B2B contract in question contains these elements which Philip just mentioned. So this is important. So as you can see, this definition from Article 22 of the Polish Labor Code has been for the last, the Polish Code is from 1970s, so for the last 50, 60 years, it's the same, but now the approach will be different because the labor inspection will be really looking at this and will have the power to change it if they think that this is really, that it resembles more the employment agreement.
Let's move on to a brief overview of the 4 types of contracts used in Poland. So the first one has already been described. It's the employment contract governed by Labor Code. This type of contract provides of course, the highest level of employee protection, but also entails the highest labor costs for the employer. Of course, employees benefit from the full scope of statutory rights, including, for example, overtime compensation, paid annual leave, sick pay, and protection under working time regulations. The remaining 3 types of contracts are governed by the Polish Civil Code, not by the Labor Code. They offer greater flexibility and lower tax and social security burdens, but do not guarantee most employee rights. So first we have the mandate contract. This is umowa zlecenia in Polish, which is a contract of due diligence, not of a result. And under this contract, the contractor undertakes to perform specified legal or factual activities. There is no employee type subordination here, and consequently, the contractor enjoys greater autonomy in a matter of performing the activities. And at the same time, this form of cooperation does not grant typical employee rights such as paid leave, as I said, or overtime protection. But however, Polish law provides for a statutory minimum hourly rate, which is applicable to mandate contracts. The next contract is a contract for specific work, so it's umowa o dzieło in Polish. It is a contract for a result. It should be used when the contractor undertakes to achieve a specific, individually defined outcome, so it's a deliverable, and the remuneration is paid for the achieved result rather than for the performance process itself. There is no organizational subordination, and the execution risk is borne by the contractor. And the last one is B2B contract. It is a contract between entrepreneurs under which one party provides services to another for remuneration. The service provider operates as an independent business entity and enjoys substantial organizational autonomy, and no employment type subordination arises. Consequently, if there is no subordination, therefore no employment relationships arises.
That's right, yes. So here you see on this slide key distinctions. So what differs employment agreement? We have employment agreement and the 3 types of civil agreements, where this B2B contract is probably the most popular, the most important ones, because it's widely used in businesses in Poland. And you will see, I will not maybe go into details, subordination, social security, risk and liability, which Philip explained earlier, and independence. Probably subordination is still the most, hard to say which factor is the most important, because subordination is something which will be measured, will be verified, and subordination is because it shows you that really there is no equal situation with a contractor and a company, but we have subordination. So, and subordination is basically fixed hours, oversight of the work by the superiors, and integration into the company business. But there's no clear, it is difficult to measure really what is the difference. They will look at the whole structure. The labor inspection will look at the whole thing, how working regulations, how the system really works, and whether you are integrated or not as a contractor. This using B2B is very popular in Poland, and it had a lot of advantages for both sides, for a contractor on one side and for the company, because contractor advantages for a contractor were better taxation and better net income. For the company, it was less administrative burden and less problems, because basically contractor was supposed to register himself as a self-employed and then as also proprietor, and he started to issue invoice for his services, and the parties used to sign an agreement for provision of services. So that's the model which is very popular in Poland. and these contracts will have to be reviewed during the audit if companies want to be safe under the new system. This is an example for you to open your eyes. It could be that, especially in IT business, it could be that suddenly, overnight, there could be audit by the labor inspection, and they can come to the conclusion that all your contractors in your IT office in Warsaw actually effectively work on employment agreements, and there would be administrative decision issued by the labor inspectorate which says, "Dear sirs, you are not freelancers, you are employees. Sincerely yours, inspector." Of course, you can appeal. We will talk later about right to appeal, but this is the new reality. This is something new which will exist on the Polish market from the 8th of July. Sorry. Why auditing B2B contracts matters? Probably we already talked about this, so there's no time to spend more time on this. This is very important. And this is the key information for you from this webinar, I think. What are the key features of subordination in an employment relationship? And actually there are 6 points, and you will see on the slide, but authority to direct and controlled work, integration into the structure of the company, employers' power to regulate and supervise, and 3 other points is power to impose sanctions and rewards, personal nature of the relationship, and exclusivity of the relationship. So actually, these are the points which should not be present, or should be present in a very limited amount in the B2B contract. So actually, this is like the negative list. So there should be point number 6, exclusivity of the relationship. So genuine B2B contractor should have more than one client, because if it's just relation with one company, this shows that this is a employment relationship. Point 5, personal nature of the relation, the same. Then power to impose sanctions and rewards. If you are under employment agreement effectively, then your superiors can impose sanctions and can provide awards during your work. So analysis of the agreements which exist in the company will be very important to make sure that any of these elements are not present. And I would like to tell you that some people will argue that it is possible to build or to draft a contract which will be inspection proven, that will be safe. Don't believe it. We are of the opinion, we discuss it, and our thinking is that there is no magic formula, there's no silver bullet that you can build a contract, you can draft a contract which will actually overcome all these problems. The problem is not a contract itself, it's a structure of the whole structure in the company, how it operates, because the labor inspection will look not only at the black letter of the contract, but will look at the position of the contract within the company structure. For instance, email address. Yes, if the contractor has email address in the company's domain, this may indicate that this is actually employment agreement. One more point. None of these points is decisive, I would say, but about subordination, because it could be that email address. Let's say that we are advising clients and we go to company ABC and they set up email address. So our email address is in our client's domain. So one could say, yes, okay, so we look like employees of this company, but if we are independent, as a matter of fact, it will be quite easy to argue, no. Even if we have that this is only to facilitate our contacts with the company, to facilitate sending emails, etc. So each point will not be per se decisive to establish that your contract should be reclassified. It's rather combination of all these elements which you put together. And then if your contractors take holidays, if they take paid sick leave, if they have email address, if they come to work from every day, if they work under supervision of the superiors, and if they sit in, if they come to office every day in regular hours, then on the whole it will be decided that this contract is employment and can be reclassified. We prepared a short study, which actually I started presenting you this. So imagine this situation where you have a IT office in Warsaw and your 10 B2B contractors in your office suddenly being reclassified as employees because the labor inspector ruled that their contracts are not really B2B. This is the case study, and actually when we talk about IT business or IT sector, this is the most vulnerable sector, because there are various voices that maybe IT sector will be one of the first of the areas which will be controlled by labor inspection. And the situation, as you can see, is a case study, but there's not much to be discussed in this case study, because I would say that in this case the case is almost lost, and Philip is expert in litigation, but it will be extremely difficult to appeal and to fight this case if these elements really show that these contractors were effectively, so they were on B2B, but effectively their agreements resembled employment law. And there will be chance to appeal against this decision, but then really the case will be decided by the court, and if these employment elements are present in the contract, there is no chance to win. So actually the only solution now for the companies, the only sensible solution is to act now and protect yourself now. So you should protect yourself now and do everything what's possible to avoid situation like in this case study. So use civil law contracts wisely, only in those situations where this is allowed by law. Do the audit and change amend everything which needs to be amended before this law comes into force. So that's briefly what we prepared for today. Now we have a Q&A session. Philip, if you can start from first question.
How do Polish B2B regulations compare with those of other EU countries? Polish B2B rules show flexibility, but face increasing scrutiny compared to many European countries, European Union countries. For instance, in France, the labor inspection has no rights to issue a decision of this type. The reclassification requires a judicial process. So as it is now in Poland, the process is initiated by the worker or by the social insurance institution or the prosecutor's office.
Yeah, okay, thank you. We have another question. I am the CEO of the software company in Poland, and we use many B2B contracts. How should I document independence of my contractors? I think we talked about this. It should be really documented. So you should collect first. It's not only collecting evidence, but first the contractor has really be in a position to be independent. So all elements which show dependence of your contractor should be eliminated. And then if you have a situation where really we have independence of a contractor, it should be showed, it should be manifested. So because it could be that really there could be case, as I mentioned earlier, there is no that the civil law contracts will be forbidden. They have to be used wisely. So sometimes it will be legal to use contract of mandate, sometimes will be legal to use contract for specific work, and sometimes will be legal to use B2B, but they have to be used in proper situations. So independence for B2B, independence or lack of subordination is crucial. So you should eliminate from this relationship anything which shows the subordination, and also there should be many elements on the side of a contractor which shows that he is independent. So he should have his own email address. He should have more than one client. He should have his website. He should take the risk of this relationship. Of course, the contract should the contract for provision of service should be on the equal basis, that there is no subordination. And so I would say that documenting independence would mainly, at this stage at least, would show that there should be no evidence that he is really subordinated. So if he is covered by the holiday roster, these people should be eliminated. There should be completely different system for people who are independent. For instance, a lot of companies buy benefit cards, like a card to the gym or to the swimming pool. And this is of course good as a company to buy these benefits, but this shows employment-like relationship. So even such small things can be indication that the relationship is not actually based on independence. So very delicate situation, and please contact us directly. I'm now talking to the author of this question. We can discuss and we can look at your situation in detail. We have one very interesting question. I think it's directed more to Philip. How do you speak to a Polish judge to win your case?
So the number one rule is be as natural in your behavior as possible. The judges are very good at spotting when someone is faking, and you need to be relaxed and natural. Yes. So that's all.
Actually, thank you for this question. Probably we could do the whole seminar on how to behave in the court, or at least body language in the court. I will add to this that, of course, you have to be natural, and judges are very good in spotting any sign of faking. But I would also say that number one rule is the number one thing is respect for the court, respect for the judge. So never interrupt the judge, never contradict the judge. But also sometimes I think you need to show genuine righteous indignation. So some will argue that always should be nice and quiet in the court and answer in a boring way, like very quietly and without raising emotion. But our approach is different. You should be natural, and being natural sometimes means that you have to show this righteous indignation. So if someone tells you you are a liar, yes. So if I answer, no, I'm not, quietly, this will not have any effect in the court. So you're right, probably, I'm right, Philip, probably, if I say you are a liar, and I said, no, I am not. Yes. So this this is nothing theoretical about this, but it shows indignation that I'm really I disagree, because but this is being natural.
Yes, correct.
And one more, we have 2 minutes for one more question. I operate, this is I think from the contractor. I operate under B2B contract with the Polish IP company, and again it's a IT company, working from 9 to 5 days a week under supervision of my superiors, which makes it very likely that my contract could be reclassified into employment agreement. Are there any reclassification risks to me, or does the entire risk fall on the company? This is a great question. Thank you very much. And the answer is probably there's also the main risk, of course, falls on the company, because reclassification means that the contract, which is only fee for services plus VAT, will be reclassified in a very complicated way. And we know that labor inspection issued already guidelines to its employees, so we'll know how the practice will develop. But definitely, upon reclassification, the contractor or the new employee will not be in a worse position than before. So, but the company will have to pay outstanding social insurance premiums, taxes, various components of the whole employment package. Also, there will be calculation of overtime hours or time during during Sundays and holidays. But it's a very good question that it could be also that some of the risk will fall on the contractor, because, as I said, the whole calculation will change, and instead of fee plus VAT will be new calculation, and the past period will. So the contractor briefly will have to make corrections to his VAT and his calculation on his side. So although his net income will be the same or will not be less than before, there would be huge complications as regards his calculation of his activity before the reclassification. So I think both parties, both the company and the contractor, should be aware of this, that when the audit happens, the labor inspection audit happens, and if they decide to reclassify contracts, the risk may fall on two sides of the contract. So the best decision really is to avoid the situation and do these corrections now before the inspection comes. There's no better option. I don't know whether I'll answer the question. We'll probably know more when the law comes into force, and there will be first decisions. So that there will be practice. But definitely, as far as we know, the labor inspection is going to follow the Supreme Court's decisions and the whole jurisprudence developed in Poland. So there will be no major shift in understanding what are the differences between the employment contract and the B2B contract.
Yes, correct.
Okay, so we have some more questions, but we want to finish this within 30 minutes. Thank you very much for your presence. We invite you. We will continue with other elements of the new law and preparation for the new situation with the powerful labor inspection. And take care. Thank you.
Thank you. Bye.